All right, guys, on this episode, we're talking about how can I protect my idea or invention, which is something you definitely want to do. You don't want to leave this exposed because I will tell you what, people will take it, they will use it, and they'll do things with it, and you won't know until it happens later on where they blow up or they make money off of it, and then you find out, wow, that was your bad for not protecting it in the first place. So what do we talk about here? We're gonna be talking about entrepreneurs and safeguarding their ideas, their inventions, and of course, theft or misuse. And some of the earliest examples of this are like certain companies that got big. Cinnabon. The guy took the Cinnabon, made the Cinnabon, which was not Cinnabon at the time, offered a opportunity for the original producer of that to help with him, and it didn't work. The guy didn't want it, and then he went out and started doing it himself. Well, Cinnabon just beat him to the punch, built the brand, built it up. The rest is history. McDonald's, if you don't know that story, look that up online. Classical example of this as well, right? So why are you going to protect your idea? Why does it matter? Well, it's preventing others from exploiting or copywriting your work. Ultimately, you need to make sure that your work is protected. And we talked about this in earlier episodes, NDAs, having things on the lock is what I call it. And you want to make sure that you do this as well, right? And what intellectual property protection is there? Number two is basically patents. They're going to protect inventions, processes, and of course products. I have patents where I've installed systems in major corporations and major hotels, and ultimately in order to use this system or fill the system, they have to utilize my patent. There literally is no other way. So what happens? We have a patent license agreement with them where they pay royalties, and ultimately they pay the royalties, they use the patent, and it's better because it's better for everybody. Why? Because if they didn't use it, it would cost them a lot more. So I'm bringing a solution to them. However, they're paying rights to use that. So patents are great. It's one of the reoccurring mailbox money options that you can have. Patents, intellectual property, that all falls under there, right? Trademarks. Trademarks, we talked about that in an earlier episode as well. Trademarks are vitally important as well. Your business name, any product names, any design marks, logo marks, text. Now you have to be compliant with the trademark laws, and a lot of this information can be found on uspto.gov. Also, you can get attorneys. You can go to Fiverr. You can find somebody, maybe they're not an attorney, but they filed a lot more trademarks and a lot more patents. By the way, that's my secret trick that I have off to the side, is I do that. I will find people that may not be attorneys, but they know the patterns, and they file a lot more than attorneys, so they know what the USPTO is looking for. Then I'll have an attorney write it up, I'll have them submit it, and it works wonders. And that might not fit for everybody. However, I do talk about that more in some of our courses and programs that we have. Virtual scaling is one of them. You can go to chriscrace.com and you can check that out. So copyrights, you want to make sure that everything is copyrighted, and you have to notice people on that. At the bottom of every website, you see the circle C, it says copyrighted. That should be on every page of your website. Anything that you publish online, you should say copyrighted with the date. What I like doing is, instead of going and updating the date every year, for instance, I have companies that were started back in 2010. So at the website, it just says copyright 2010 plus, or 2010 to current. Make sure you check in your local state, your local area, your local jurisdiction, whether it's your country or whatnot, and have a lawyer make sure that you follow that or check that, right? Because you don't want to be in violation of the notice, because notice is just as important as the copyright itself. If you don't put somebody on notice that they're infringing on your trademark, your copyright, or your patent, you are actually the one in violation. That's how the USPTO looks at it. So make sure that you have that there. Make sure that you notice everybody. If somebody is infringing on your patent or your trademark, you have to notify them. I'm nice. I give a grace period, and then I notify them and say, hey, we've given you this grace period. Now it's time to start paying the royalties, or now it's time that you know that you're infringing. And that way I'm accounting for that lost time as well already, so that they're not coming back and saying, hey, well, you didn't notice us here. You're the one in violation. You want to make sure that you have your ducks in a row and things are in line here. Now also, trade secrets. Trade secrets themselves are going to be anything that's internal processes, formulas, the way you do certain things, how you assemble products. There's certain, let's see, give an example here. If you're manufacturing a circuit board, the circuit board could technically be patented if it falls into a unique setup, right? So you could patent this circuit board, a utility patent, a usage patent, product patent, and the process on that you could perhaps patent as well. Now, a trade secret as is going to be the process on that. So you don't want people to know that, right? So what you're gonna do is you're gonna trademark any of the logos, the brand names, the product names that go along with that named process. So the name can be trademarked, the product name can be trademarked. You can have a trademark for that. Now the trademark does not cover the patent side of it. They're two totally different things. So the trademarks deal with names and logos and slogans, whereas patents are processes, products, inventions, and hard products, and if you will. So with that said, safeguard internal processes. Those are all trade secrets. Any one of these that I've just talked about, you want to have an NDA for, first and foremost, right? So that people know, and therefore you're protecting yourself. Now, how to choose the right protection. Decide, do you need a patent, a trademark, or a copyright? You have to decide on each one of those. They're three separate things. They do have bleed over in which some can incorporate others, but just because you have one does not mean that you automatically get another one or that you're safe, right? From somebody infringing on that. And there are laws out there that show, and there's businesses that are actually, they're built on the basis of they go search for people's patents because now it's public information, and they will look at what the patent discloses and they'll make the product 20, 30% different, whatever the case is. I'm throwing out an arbitrary number, right? But they'll make the product just a little bit different, and their whole business model is built off of building other products that are similar to those that are patented. Rare, but they're out there. And why does this matter? So sometimes patent pending is better than actually having the patent. Why? Because patent pending, you don't have to disclose exactly what you're doing. Perhaps your trade secret is in that patent. Perhaps there's a process or the way you make something that's in the patent itself, and you don't want that disclosed. I say that is patent pending because you could tell somebody it's patent pending, which means you have the intent to file the patent and you are still claiming that this is your work. Now, this is where it gets into the law. You want to go ahead and talk to a lawyer about this, but ultimately they will be the ones that tell you, here's what you need to do, here's how you need to structure this, but just know that when you do file a patent, your entire process is going to be public. It is public information, and that gives somebody the ability to come in and say, okay, they use this, they do that, and they know exactly what is going on. So with that said, what is the role of legal help? Well, you need to streamline the process. There's a lot of things you don't know. A lot of times people go online now and they Google stuff. Of course, they GPT it now, right? Well, guess what? That gets you so far. And I say that because even the best people at writing the right prompts, yes, GPT knows best. However, it's still prone to errors. And I can tell you the last thing that you would want is to have an invention or a product, patent it, or go through the GPT process, as they call it, understand everything, and then you go to file a patent and you mess something up, or you have somebody that's going to file it and you mess something up, and then they come back later and you're going in multiple revisions, which each revision is going to cost more. You have to submit more documents, you have to refine things, and it costs money. So time is money. Make sure you get this right up front. Have 2 or 3 different people. You can get onto an hour consulting call with a patent attorney or 30 minutes at a certain rate. We talk about that in our virtual scaling system program, and you can just get feedback. I like getting feedback and paying for the information so I don't have to Google it online, or I don't have to GPT it, because I will balance the GPT and what I'm hearing, and I GPT it, I go and I ask the questions that I need to ask, and I get clarification on those in a dialect and a conversation that you can't get online. Outside of that, what are common mistakes to avoid? Publicly sharing your idea before securing protection. You don't want to do that, okay? You don't want to share your ideas. We talked about NDAs at an earlier segment. Go ahead and watch that. Non-disclosure agreements are critical here. They don't protect you from everything. However, it gives you the right to go after somebody and sue them if they take this information and they start acting on it and they start gaining any ability in the marketplace, money, whatever. They disclose it, they're violating an agreement. That's why it's there, okay? File trademarks and patents early. You definitely don't want to wait on this. The earlier you file, the better. For me, when I do a business, when I do a product name, I put TM right after it. I do TM after the business name. I'm trademarking that. I'm informing the public that I'm trademarking it right away. Now, I actually go get it trademarked. That's one of the first 10 steps in business that I do. Trademark the business name, boom, done. You can go into industries, you could trademark your product names, it's best. There's a whole segment that I talked about that on early on. Now, assuming verbal agreements are enough. Don't assume verbal agreements are enough. They're not. I can tell you right now, they are not enough. People do not honor the verbal agreements, and neither does the court. It's a conversation like this signed on a piece of paper so that somebody can come back 5 years later and review that and say, that's actually what we talked about, literally in black and white. It's not a he said, she said, because when you know that, it's three sides to every story. It's yours, it's mine, and then it's actually what happened, which sometimes nobody ever knows about, right? Because we don't know about